All right. Good afternoon, my friends and followers. I'm your lawyer, Patrick McGeehan, and I'm your best friend at your worst time. Welcome to Weekly Update with Patrick. We have some announcements coming out today that came out late last week. Anyway, new as far as court orders go. Oh, and don't forget to catch us on Wednesday, this coming Wednesday on, let's see, what's the date on Wednesday? Today is the 27th, 29th. On April 29th at 6 p.m., I'll be covering this case that I ordered from the police department of a Florida sheriff's deputy. A guy who shot a Florida sheriff's deputy got arrested for murder, and guess what? They let him go. So we'll talk about that case. Very interesting case, at least to me anyway. User or follower sent that to me and asked me what my comments was on the case, and I thought it was such a good case that I would cover it in detail for you to let you know how it worked out and why it worked out the way it did. Anyway, from Broward County, we have amended 17th Judicial Circuit misdemeanor plea docket. If you are arrested for a misdemeanor during the time the courts are closed and you want to resolve the case, you can resolve the case via Zoom or telephone. Let's see what it says. If you want to do that, unrepresented individuals and attorneys shall contact the Broward County courts, the clerk's office, and get it set on the remote docket. The cases will be resolved either by telephone or using the Zoom platform. The resolution is pursuant to a plea agreement between the state and the defendant. All parties and the defendant must stipulate to resolving the case remotely. And then it goes on to list everything you have to do. There will be no face-to-face contact. All hearings are remotely. The clerk of the court, the court reporter will attend remotely. If an interpreter is needed, it is responsible of defense counsel or the defendant, if they're unrepresented, to get an interpreter. Anybody wishing to place a case on the docket shall contact the assigned judge by calling or sending an email. So they say the clerk's office at first, and then they say the judge's JA via email or phone. If the court determines the case meets the criteria, a date and time and mechanism of a hearing, whether it's phone or Zoom, will be provided. The court reserves the right to accept or reject any case from the special docket. Prior to the hearing being heard, the court shall make efforts. All efforts must be made for the defense counsel to contact the state attorney's office and enter into plea discussion. So if you get arrested for a misdemeanor case in Broward County, you can resolve it even though the courts aren't open to the public if you want to do that. What does that mean in summary? If you want to take a plea or cop a plea, you can do that. Now moving on to Dade County, as they stated last week, they're trying to come up with a plan to open public parks, marinas, and golf courses. We are all for opening the marinas because I can't go anywhere in a boat and go fishing without the marinas open. Anyway, as far as that goes, yesterday, Miami-Dade County announced an emergency order allowing for the reopening of public spaces. There's no real details. They're working on an order. They're trying to finalize the final version of the order. They're working in conjunction with the county attorney, requiring specific health practices for parks, waterways, and golf courses that wish to reopen amid the pandemic. Let's see. They're brainstorming on ideas on how to get the economic engines up and running. According to the mayor of Miami-Dade County, they have hired 400 people, some who were displaced security workers from Hard Rock Stadium, as well as school crossing guards. And these 400 people that were put out of work by the pandemic are going to be hired by the county or have been hired by the county to help enforce social distancing measures at parks. So you're going to have security guards and school crossing guards policing you at the county parks. Let's see. This allows the order is going to allow the cities to open parks under specific guidelines, but the municipalities can enforce tougher rules or refuse to open altogether. So if a city within Miami-Dade County wants to open their parks, they can. They can make the rules tougher, or they can keep their parks closed. Here's the kicker. People who do not follow social distancing rules will face a $500 fine. Mayor pledges zero tolerance for people who don't follow the rules, and the rules will be carefully or clearly spelled out at parks, marinas, and golf courses. He did not mention when they are open, but expects to announce a plan and the details in an emergency order on Monday. Well, today's Monday. I haven't seen the emergency order. Usually they come out in the afternoon just before 5 o'clock. But if I was betting, I'm betting that it comes out Friday, because Friday is May 1st, and May 1st works into some of the previous mentioned guidelines. Then they're going to work on the next phase of reopening, which will focus on non-essential business. So there you have it. That's the latest word from Miami-Dade County as far as parks and marinas open. Last week, also in Miami-Dade County, the chief judge issued administrative order 20-06A1, which amends the previous administrative order 2006 regarding family law case procedures. And if you didn't know it, the courts are up and running. They're just not open to the public. Cases can still be filed, motions can still be filed, all kinds of pleadings can still be filed. Hearings are being conducted via Zoom and telephone. We've done a bunch of them here. So it's progressing along as best they can. Myself and other attorneys who practice in the family law area are well ahead of progress compared to the courts. The courts are lagging behind. We're filing everything we need to file. We're doing our business, and we're ending up waiting on the courts because all judges are not online, but more and more are coming online. In criminal cases, I haven't seen any movement in criminal cases. They announced that they were starting to do Zoom hearings, but I have seen no Zoom hearings. I've had none in my criminal cases, and I don't know any other attorneys that have. So it looks like criminal court is still either very slow or down and out for a while. All right, for the administrative order, it applies specifically to family law cases. Contact with both parents. This is one of the titles. I'm going to read the highlights for you. The court expects all parents to continue to adhere to all final judgments, temporary orders, settlement agreement, and all other orders of the court awarding parental responsibility and time sharing, unless both parents agree in writing to a different time sharing schedule on a temporary basis. So what does this mean? That's very helpful. You know, these are just guidelines. This is very helpful in the situation that we're in, and communication is paramount. So if you need to work out a temporary time sharing agreement, alter the time sharing agreement that's currently in place, you can do that. But make sure that you have it in writing. Unless otherwise prohibited by an existing court order, each parent is prohibited from unreasonably restricting access of the children to the other parent. And be mindful of that. They are going to, if you unreasonably restrict access to the kids, or you unilaterally terminate time sharing for unreasonable measures, most likely you're going to get hammered. The regular time sharing that's in a parenting plan shall continue. This has to do with summer time sharing until the date of the school district or governing official designated in the parenting plan announces the last day of school, at which time summertime sharing begins. So when Miami-Dade County says, okay, some classes, regular classes are over, now it's summer, on that day, you go to what your summer time sharing plan is. Until that day, you stay on the regular time sharing, or you're agreed to in writing modified time sharing. Exchanges that were to take place at school shall be arranged between the parties in writing by email, text, or parenting computer application. So figure out where you were going to exchange the kids because the schools are closed. I'm sure if you have kids and you're in that situation, you've pretty much already figured that out. In the event that parents can't agree to an alternate arrangement, a motion shall be filed with the court to be handled in accordance with any subsequent administrative orders related to COVID-19 procedures. You have to communicate. My personal opinion, and this has worked out in all of our cases, is you should be able to agree upon an alternate place without having to go to the court. I mean, you're going to spend a lot of time. You're going to wait in line to get your case heard, and it could take a while. So it would be in your best interest to agree to a reasonable place. Now, if it's a crazy place, like, some place that's not safe or some place that, is out of control, don't agree to it. But if it's like at a police station, at some business that's open in the parking lot, a mall parking lot, Publix parking lot, or whatever, or each other's house, if you can get along that well, that's fine. All right. If the governor or let me get the language right here. If the governor or any other government officials enter an order that says you must remain in your homes and are not allowed to go outside your homes for activities to obtain essentials such as food, time-sharing exchanges will be suspended. So basically, time-sharing will be suspended. If the government says, hey, we're on total lockdown, everybody's on house arrest, and we are not allowed to go out, not allowed to go to Publix, Winn-Dixie, or whatever, then time sharing ceases. The exchange ceases. Whoever has the kids at that time keeps the kids. Okay. So the rule of thumb is if you can go to Publix and Winn-Dixie, you can exercise time sharing and exchange your kids. If they just enter the safer at home order, which is what we're under now, the time sharing will continue to take place as previously ordered or agreed upon. So once again, if you can go to Publix or Winn-Dixie, you can exercise time sharing and exchange your kids. This administrative order is for general guidance. However, nothing in this order prevents the assigned judge from issuing specific orders based on other factors and individual cases. If you have to file an emergency hearing, parents are strongly cautioned that unreasonable, hurtful, or destructive behavior may be sanctioned by the court. So once again, there's that unreasonable, and they threw in hurtful or destructive. Don't unreasonably withhold time sharing. Make sure you communicate with the other parent and you work things out. Fortunately, in our cases, we've been able to work out all the time sharing issues in all the cases. I reported last week or the week before about an ER doctor who got her time sharing terminated simply because she was an ER doctor and she could contract the virus. The judge terminated her time sharing or suspended her time sharing. Fortunately, they appealed right away, and the third DCA stepped in and nixed that order. And it has to be, they have to have something more a better basis than just she could be exposed to, or you just could be exposed to the virus because of your working conditions. And that deals with, that deals with Section 3, emergency motions and expedited hearings. And it gives in subsection C, subparagraph C, and I'll put all these orders and links down below. It tells you if you want to file an emergency motion to modify or temporarily suspend time sharing due to concerns about increased risk to a child or others from transmitting COVID-19, the motion should address items such as, and it lists everything you have to address. You can't just say the other parent is out traveling around, is a first responder, is out meeting people, could be exposed and all that. You have to address all these 9 factors that are in here, and then you have to swear and affirm under penalty of perjury that they are true. Basically, that tells you no BS motions. Make sure if you file this type of motion, you have sufficient grounds. Self-represented parties, if you need procedural help, you're urged to contact the Family Court Self-Help Program at the Family Law Courthouse at 175 Northwest 1st Avenue, room 2441. They didn't put a phone number on here. but I'm sure it is in there. And they say in there, they say in this order specifically, self-represented parties will be governed by the same rules of law, procedure, and evidence that lawyers are required to follow. So they're not messing around, people. They're taking the family court division of the circuit court is taking family law cases very seriously. They're working on them. And they are looking, I've heard rumors, I don't have anything substantiated, but they are taking very seriously any motions to suspend time sharing, which are not based on sufficient facts. So if you file those motions, make sure that it's a sufficient basis. And you may even want to hire a lawyer just to look at that motion if you don't have a lawyer already. Certainly, if you have a lawyer, your lawyer is going to know what to file in that particular motion. That's it. That's the highlights of the latest order, and that was sent out last week on the 22nd. So 5 days ago. So what was that, Wednesday? I think that was sent out after the Wednesday live. Of course, if you have any questions, you can always feel free to DM or email me. On all the platforms on Facebook, I am in the group Ask a Florida Divorce Lawyer. You could join that group. It's a private group, and you get to ask me specific questions. I have a Facebook law firm page, the law offices of Patrick McGeehan. I am on Instagram, TikTok, Snapchat, and Tumblr as the Magic City Lawyer. And you can also get me on Twitter at PJ McGeehan Law. You can DM me or email me direct, patrick@pjmlawyer.com. That's it as far as court updates and opening and closings as far as Miami-Dade County goes. If I get anything interesting or urgent in the meantime, before next Monday or Tuesday, I'll certainly put up another video. I checked Palm Beach County. It doesn't seem that anything has changed in Palm Beach County. The only thing I want to remind you is, although the courts are closed for public access, the judges are working on cases, and specifically for domestic violence cases. You can file domestic violence cases in Dade, Broward, and Palm Beach the same way you could file them before. The only difference is you can't do it at the satellite courthouses. You have to go to the main courthouse in each jurisdiction, each circuit to do it. So you would go to the Family Law Courthouse, 175 Northwest 1 Avenue in Miami-Dade, the Broward County Courthouse on Southeast 6th, and the Palm Beach Courthouse on North Dixie. They will allow you access to the courts for that. Other than that, only the essential court functions are going on, which, probably to everybody applies, bond hearings, stuff like that, domestic violence. Those are going on, and which lawyers can attend, although there are specific rules for it. So if you do get arrested and you're being held no bond, or you have a high bond, those cases can be addressed. Like I said, again, join me Wednesday at 6 p.m. this coming Wednesday. I'll be going over a case involving a shooting of a Florida sheriff's deputy, where the person who shot the deputy was arrested and ended up getting off after 5 years. It's a really interesting case, how he got off. He basically got immunity from prosecution. A follower sent me that case information. I ordered all the police reports. There's a few of them. They're right here. I'll be going over that case in detail and explain exactly how it happened. It's pretty interesting. That's it. Let me check all the platforms and see where we're at. Today we're on Instagram, TikTok, Facebook, and YouTube. Let me see if we have any questions popping up on any of the other platforms. All right, let's see. Wide awake and sleeping, how are you? Do you give life advice? I mean, if it pertains to lawyering and things I know about lawyering, I have a section on my YouTube channel about lawyer life lessons, things I've learned from being a lawyer. I've always said that I learned so much from my clients, it's ridiculous. I learn more from my followers and clients, you guys, than, it's a whole nother experience, like a whole nother degree. You guys give me such good insight on different things. TD3 Law, Patrick, we have a group of TikTok lawyers on here. Let me know if you would like to join our collab. Great group. Yes, send me that info. I certainly would. All right, Big Stack 81 question. When will the courts open in Kansas? I have no clue. SD grad student stumbled on an interesting legal fact. Today was the day in 1861 that Lincoln suspended habeas corpus. Okay, I'll take your word for that. I know the year was 1861, but I don't know the exact date. That looks like it for TikTok. We're good on Facebook, good on YouTube, and let's see, let's check Instagram. Looks like we're good on Instagram. Not a lot of questions today. A short one for the update. But join me again Wednesday. We'll go over another cool case. If you missed last Wednesday's case, you may want to go back and look at it. I'll put a tag up here in the top on YouTube on the replay. It was a case that involved a murder by a suitcase up by Orlando. Pretty cool case. It was very interesting. I went over some of the facts. I got a lot of follow-up on it, a lot of questions that I'll address in subsequent videos related to everything from self-defense, stand your ground, castle doctrine, the whole 9 yards. And I'm sure after this week, I'll get a bunch more. So I'll collect them and I'll outline a video and put that up. Anyway, thanks for joining in. It's always my pleasure to have you. I'm always humbled by the number of people that come in to listen to what I have to say and to join me every week. And I am very appreciative. Like I said, I learn more from you guys and from my clients than I probably ever did in school. You guys give me a great education in life and life lessons. And some of them I've reduced to videos, and there's a playlist on my YouTube for that. All right, we got one more come in from Again off. How long is the statute of limitations for assault? I don't know about where you're at, but in Florida, under Chapter 95, the statute of limitations, unless stated otherwise in the specific statute, which for assault, I don't think it is 4 years. All right, thanks everybody for coming in. I will see you Wednesday. Be there, be square. I look forward to it. Thanks again. Bye.